Thank you so much, John, for the incredibly generous introduction. Because I was going to begin with the sectarian joke, and now I feel a little bit bad, about it. You can ask me later. As John mentioned, my role this morning really is to speak to you about the state of play in New South Wales, where we are now and where we're going. But before I do that, I just want to briefly look at where we've been. So this was the state of play legally around the country in November 2017. So November 2017, all of the public hearings for the Royal Commission into Institutional Responses to Child Sexual Abuse had finalised. So this was the end. This was the end. And if anyone had thought for the churches that those 5 years of the Royal Commission had been particularly brutal, and they were, this was still the state of play at the end of there when it comes to the law. Wind the clock forward just 5 years, and that's what it looked like. So if as difficult a time as the Royal Commission was for the churches, actually the 5 years following that Royal Commission, I think, were more difficult when it comes to the social issues. And part of that, I do believe, is because the moral authority of the churches, the Catholic Church, I would say primarily, other Christian churches as well, though, had been challenged in the public square for very good reasons. Our leaders decided not to engage on public issues, but this is the result of that window. If I look forward to probably the end of next year, this is where I think we will be. It's obviously a particularly dramatic presentation, but I think we need to be realistic when we begin these conversations about where we've been and how quickly these things can change. So as we look forward to the next 6 months in New South Wales, actually and federally, this is what's coming our way. So we'll have the finalisation of the Australian Law Reform Commission inquiry into religious schooling, and particularly whether or not religious exemptions to anti-discrimination law when it comes to religious education should be removed. The report on whether or not Australia should have a federal Charter of Rights. The New South Wales Law Reform Commission inquiry into the overhaul of anti-discrimination laws. Alex Greenwich's Omnibus Equality Bill that will seek to amend about 20 different pieces of state legislation in order to achieve the quote-unquote goal of equality. The commencement of New South Wales euthanasia regime, and also legislation introduced into Parliament around a ban on so-called conversion practices. In some ways, I would say the Australian Law Reform Commission inquiry, the New South Wales Law Reform Commission inquiry, and the Charter of Rights to somewhat a lesser extent are the most dangerous, particularly for the nature of religious schooling. But religious schooling is an entire topic of one of the presentations this afternoon. So I'll let them deal with religious schooling and the impacts on religious education in this afternoon's presentation. And instead, I'll focus on the things that won't be brought up then. So the 3 areas I want to look at in our conversation this morning: the implementation of euthanasia in New South Wales, the ban on so-called conversion practices, and the Alex Greenwich Equality Bill. So I'll start first with euthanasia. That regime commences on the 28th of November, so just a few weeks' time. One of the things that's most often talked about when it comes to the impacts of euthanasia on religious freedom and on religious institutions has to deal with religious aged care facilities. So the New South Wales legislation requires that faith-based aged care facilities, residential aged care facilities, allow all parts of the euthanasia and assisted suicide process on site. So from the very first consultation up until the administration of lethal drugs. And while the individual institution can technically object, they must allow others on site to facilitate every part of that process. This is not required in Victoria, Western Australia or Tasmania. So for all of the jokes all of us like to make about Victorians, their regime, funnily enough, protects religious freedom a little bit more than what New South Wales is going to purport to do in the next few weeks. And I have to say that when Victoria protects religious freedom better than you, it's a pretty bad indictment, right? So because of that, we're still lobbying the government and the opposition to allow us to be in line with these other states who don't seem to be having a problem with euthanasia access, right? If we're looking at the numbers of euthanasia deaths that are increasing at every report in all of these states, it doesn't look like allowing institutions a full right of conscientious objection seems to be hindering access to euthanasia. If anything, the numbers are much higher than what was already predicted. And if we look to Queensland, they're averaging more than 1 death a day already. So while we don't know how our lobbying efforts will play out for individuals and institutions exercising their conscientious objection rights, we can see that there are a couple of places where this is really going to hit the rubber's going to hit the road in the next few weeks. So one way is that institutions are required to publicise their conscientious objection. So if you're a faith-based aged care facility, you have to have signs up on your website, in your brochures for incoming residents and things like that. You're going to have to advertise your objection, your conscientious objection. And while legally you're entitled to do this, what we're seeing is increasing media pressure against institutions that choose to do this, up to and including calls for the removal of government funding. And, sorry, excuse me. Anyone who reads The Guardian will see that they have sort of quite a regular campaign on stripping any federal funding or any federal or state funding to healthcare facilities that seek to exercise a conscientious objection. And while a lot of our focus has been on institutions and institutional rights, there's also a significant problem for individual doctors that I just want to spend a little bit of time talking about this morning. So the euthanasia legislation allows individual doctors the right to refuse to participate in the request and assessment process, to prescribe drugs, or to supply or administer lethal drugs, or to be present at the time that they're administered. But there are a lot of aspects to patient care that don't come in with those specifically named carve-outs, such as providing a person with information, providing them with a referral, or anything like that. And this is especially difficult when it comes to junior doctors. So Wilmot and White were the Queensland University academics who put together the Queensland euthanasia legislation. And they recently came out with a paper that said, that talked about the impact of conscientious objection on junior doctors. And they said that this is actually quite an ethically complex area because junior doctors are in a different position of agency compared with their senior colleagues. They're at the bottom of the medical hierarchy. They act under the supervision or direction of their more senior colleagues. And a lot of studies have shown the practical difficulties that junior doctors have in speaking up or acting in line with their values because of their junior position. They're dependent on their senior colleagues for training opportunities and career progression as well. And many of the tasks associated with euthanasia and assisted suicide that are relegated or that are related to junior doctors and that what they're asked to perform don't clearly fall within the areas about which they're able to conscientiously object. So we've asked New South Wales Health directly about this, and the Chief Health Officer, Dr. Kerry Chant, is in charge with implementation, and she just seems to say, well, look, if any problems arise, just let New South Wales Health know. So just let us know if there are any problems that people are experiencing. They don't have a proactive plan to protect institutions or individuals who are announcing their conscientious objection. So I guess for us in the room, that's, I think, where the first challenge, if we're trying to be practical, this is one of the things where we need to step in. So we need to be vigilant on the institutional side, but I think we also need to ensure that the institutions we represent are providing support for individual doctors, a safe and perhaps even an anonymous place where they can come and report the difficulties that they're having, and we can perhaps act as an intermediary with government, with New South Wales Health or something like that, to bring some of these to light. Because and the people who wrote this paper are highly pro-euthanasia. They drafted the euthanasia legislation. If they're saying that there's a problem for the conscience of individual doctors, that's something I think we need to be very live to, and I think we need to be a little bit creative on how we're going to be protecting those who are standing up for the dignity of life. So that's euthanasia. That's where we are, but I also think there's a practical challenge to us in moving forward. I next briefly want to speak about conversion practices. So prior to the election in March, the government promised to implement a ban on so-called conversion practices. And conversion practices are often publicly described as practices that seek to change a person's sexual orientation from homosexual to heterosexual, and include long-abandoned practices like electroshock therapy, giving somebody sort of nausea-inducing drugs and then exposing them to homosexual pornography, trying to amend the way somebody talks, their gait, and things like that. There's no evidence that any of these practices occur anymore in the time when I think that we've been able to register complaints about these for about the last 20 years with the Healthcare Complaints Commission, and I think they've received something like 9 complaints in 20 years or something like that. So these aren't practices that are occurring frequently, if at all. And I think that most people would agree that practices like that are against the dignity of the human person anyway, and it's not something that we would buy into if we're people who uphold the dignity of every human person. But that's how these conversion practices are being sold, or the ban is being sold, when really they go far beyond, because 2 things that they want to ban is suppression of sexual orientation, and I'll come back to that in a second, and also changes to somebody's gender identity, which is obviously a lot more fluid. So we're waiting to see the government bill. That's also due to be tabled later this month. November's a big month. Nobody go on early Christmas holidays. But we already have a little bit of an idea because of some of the problematic aspects that came out in the consultation. So the first is the proposed ban on suppression practices. So if you define a suppression practice as encouraging someone to refrain from sexual activity, then if you ban a suppression practice, you're not only banning but criminalising telling somebody to reserve sexual activity for heterosexual marriage. So basically, you're banning and criminalising the Christian understanding of marriage and the proper place for sexual activity. And it's not just Christian morality. The same reservation of sex for marriage is shared by Jewish, Islamic and Hindu faiths as well. If suppression is counted to be asking somebody to refrain from sexual activity, it also puts encouraging Catholic priests to be celibate, or putting a requirement of celibacy on the Catholic priesthood at risk as well, because again, you are suppressed technically by the definition in the law, you would be suppressing somebody's sexual desire. So suppression is a big issue, and we're hoping, we've been speaking a lot and making a lot of representations. Mike will know better than many about how much we've been pushing the government on this issue. But if the bill that comes out later in November seeks to ban suppression practices, what we're talking about is telling anybody that any type of refraining from sexual activity is against law. And this includes heterosexual sexual activity as well. So you could be saying somebody could come to you and say, I'm really tempted to cheat on my spouse. I've got somebody at work, I'm really attracted to them. If you said, no, actually you should live in accordance with your marriage vows because that's what God wants of you, that's what the church teaches, that's what the faith teaches, that in itself could put you on the wrong side of the law. So this isn't just about LGBTI issues. In many respects, they're a distraction. This is actually about Christian sexual morality. That's when it comes to sexual activity. When we move on to the conversion or suppression of somebody's gender identity, that's another story, because if you have somebody, if you have a 7-year-old boy who insists that they are female, telling them that they're not, trying to assist them in being comfortable with their natal sex could also fall within the definition of suppressing or converting their gender identity. And this is particularly insidious when it comes to children, because there's so much medical unrest at the moment about what they call gender affirmative treatment for children experiencing gender dysphoria. So in the past 12 months, the use of puberty blockers and cross-sex hormones have been banned in Sweden and the United Kingdom. Norway has defined these treatments as experimental, and one of Australia's 6 biggest medical insurers, MDA National, has ceased to provide insurance for medical practitioners who prescribe gender-affirming hormones to kids under the age of 18. So medical practitioners, parents, pastors, teachers, counsellors, anyone who doesn't want to push gender-affirmative treatment because of the unknown long-term risks, under these types of laws would actually face criminal or civil penalties for doing so. So it's an extraordinary thing. The world is going one way, saying we need to put the brakes on. And New South Wales is currently seeking to force the hands of parents, I think, I don't know if Neil Foster's here, put the thumb on the scales, I think is how he describes it, of putting doctors in a particular direction. Not only doctors, parents, teachers, counsellors, pastors. So gender identity, particularly gender dysphoria in kids, is a really big issue when it comes to these bans on conversion practices. The next one, obviously, is the limited protections offered to expressions of religious belief. So this is where the government's trying to get around their pre-election promise of no ban on prayer or preaching. So prior to the election, Freedom for Faith held a number of candidate forums, and then there was a leaders forum held out in Parramatta. And the then opposition leader, now Premier, said that taking offence at the teachings of a religious leader will not be banned. Expressing a religious belief through sermon will not be banned. But how this is playing out at the moment is that the proposed laws, at least what we're getting from the consultation paper, would only allow the expression of a religious teaching if adherents were not exhorted to follow that teaching and have any impact on their life, which renders religious teaching kind of meaningless, right? It's sort of like, well, it renders it to be an academic exercise. So you can get up and say, well, this is what the Bible says, this is what the church teaches, this is what a Christian would do. But if I said, and now I want you to apply this to your own life, that's where the line is drawn. So that's another thing we really have to be careful of when this comes out, because otherwise what's the point of preaching and teaching if you're not asking somebody to apply it to their life? Do something else on a Sunday morning, to be perfectly honest. It also then obviously prevents any type of one-on-one ministry. And again, this isn't just about LGBT issues. This is, teaching teens to save sex until marriage, any type of Christian sexual morality being outlawed when you're asking the individual or encouraging the individual to apply it to their lives. And then, and that's just the positive aspects of the teaching, telling somebody that it's a sin, telling somebody that there's eternal consequences for the choices that they make in this life, that would be seen even more extreme and more abhorrent under some of the proposals. The next one is the ability for the Anti-Discrimination Board to conduct what they call own motion investigations. So what the proposals would do would allow the Anti-Discrimination Board, even without a complaint, to conduct investigations into what they think might be systemic issues. And that would allow them to do everything like compel witnesses to come and testify, to subpoena documents without a complaint being made. Now, I've been accused a couple of times of being a cynic, but if anybody doesn't think that this is going to be things like subpoenaing sermons, and having targets on particular churches known for traditional religious teachings, then I've got a bridge in Brooklyn that I want to sell you. This is where the own motion investigations into systemic issues really come down to giving the Anti-Discrimination Board the ability to monitor what churches are doing and what they're preaching and what they're teaching about sexual ethics. This isn't only giving them the power to do it and a significant overreach of the state, it would dramatically affect the freedom of faith communities to teach their beliefs. The next one is about consent. So at the candidate forums that Freedom for Faith organised, all of the Labor MPs gave the following promise: any legislation to ban conversion therapy or suppression practices must not outlaw individuals voluntarily seeking medical, health, allied health or other advice and assistance regarding their personal circumstances. So that was the pre-election promise made. The consultation process so far and the consultation paper we received says that consent is not relevant. So even if somebody seeks out the help, even if they come to you and ask you for prayer, for counselling, for advice, that doesn't let you off the hook. So again, we're hoping, and we've been making significant representations to government that this will change, but that's another one that we need to keep out for. Like I said before, when it came to gender affirmative treatment for kids, Australia really does seem to be pushing ahead where others are slamming on the brakes. So the UK and Sweden have recently announced that they're not going to go ahead with their announced bans on conversion practices because of the fear of how it will affect parents, how it will affect religious communities and everything like that. So they've actually realised that this is a really big issue and that they're not sure how it's going to impact faith and families, and so they've just put the brakes on it and said we're not going to do it. Whereas that doesn't seem to be the case here in Australia and particularly not here in New South Wales. So I would say this conversion practices bill is probably our most urgent task. All of our tasks are urgent when it comes to defending faith and defending freedom, but because this impacts so much of what we can teach, the relationship between parents and children, teachers and students and everything like that, and also the dramatic effects that it can have on our young people, the life-altering effects that it can have on our young people, I think this becomes our most urgent task. So again, if I'm leaving a practical outcome for this, as the legislation rolls out in the next few weeks, this is something we need to be live to and our communities need to be live to. And I came in a little bit late this morning. I'm sure Mike has already plugged contactyourmp.com.au, but if not, that's the end of the conference. Okay, well, there's a spoiler alert. Freedom for Faith has set up an easy way for your communities, all of our communities, to be engaged in this fight, and that's something that I really think we need to be on. And then just briefly on the Alex Greenwich bill. So in the last sitting of Parliament, Alex Greenwich tabled two pieces of legislation. One was a ban on conversion practices, and one was an omnibus equality bill that seeks to amend a whole bunch of legislation. The government has indicated that it's not going to back his conversion practices bill because they have one of their own, and also that anything in the Greenwich bill that touches anti-discrimination law, they also won't support because they have one of they're conducting their own anti-discrimination review. So I won't cover those aspects of the Greenwich bill, but there are a few other things in there that Greenwich has put in the name of equality that I think we need to be aware of. So the first is adoption and forcing faith-based adoption agencies to place children with same-sex couples. That's one of the inclusions in there. If we move on to gender, removing the need for any type of medical or surgical intervention in order for a person to legally change the sex on their identifying documents. And this is what we call self-ID laws. And so what that does is it puts all sports, it puts women's only spaces and everything else at risk, because once somebody's identifying document has their sex listed as male or female, then they should get access to all of those places, even single-sex schools. And there are some interesting examples in the legislation as well, or in the draft legislation. things like security guards. So at the moment, if you're going through, I've been through a number of airports in the last couple of days, you go through the scanner and somebody needs to do sort of another search. Often you can ask for a male or a female to conduct that search. In this case, a person who has changed their sex on their identification documents can choose someone of whatever sex they feel comfortable with, which might seem like a right for that person, but then questions arise, I think, for the rights of the security guard. Like I'll use the example, there's an imam who we do a lot of work with, and when I greet him, he doesn't shake my hand because in Islam it's very serious about men and women who are touching each other. But under these types of laws, you could require an Islamic male security guard to give a search to a female who identifies as a male. So the rights just go one way. I know it sounds like a very simple idea, but it actually, when it comes to religious freedoms and religious practices, it can hit the ground in some very particular ways. On gender as well, they've put in, Alex Greenwich has put in a provision that says that a child is able to consent to gender-affirming care even when it has permanent effects on things like fertility. So I think this is looking to get around the initial ruling in the Tavistock case in the UK, which said that children 16 years and under can't actually consent to medical treatment that will affect things like their fertility, because they don't have the full understanding of what it means in order to then give it away so easily. So this is trying to actually shield the law against any type of challenge that a 14-year-old, a 15-year-old wouldn't be able to consent to making them permanently infertile. Additionally, and I think probably more controversially, it would allow for gender-affirming treatments even if one parent doesn't consent, so puberty blockers, cross-sex hormones, and even if neither parent consents. So this undermines the parent-child relationship in a really significant way. Overriding the wishes of parents when it comes to a child's medical treatment is very, very rare in Australia and usually requires a court order. If we think about sort of the classic cases that they teach you in law school are about when a child needs a blood transfusion but their Jehovah's Witnesses parents decline that blood transfusion because it conflicts with their religious beliefs, a hospital must obtain a court order before they provide any type of blood product to the child. And so if that's the case and that's a situation where the child's life is at risk, putting in a law that says that parents don't need to consent to gender-affirming treatment given to their child, and that's something that the child and the doctor can agree between themselves, is a dramatic shift in the way that we've looked at the relationship between parent and child. And it's just been snuck into this law, and it's something I think we really need to call out. Moving on from sex and gender and things like that, just briefly to prostitution. Mr. Greenwich would like sex work to be a protected attribute in our anti-discrimination law. So you can't discriminate against somebody on the basis that they are now or have been a sex worker. So this means if your school principal has a side gig, or an OnlyFans page or something like that, that's not something that you can take into consideration, your senior pastor in your church or anything like that. Another aspect of this bill is to permit solicitation in or near churches and schools, allowing for overt public advertisements of commercial sex services. So allowing somebody basically to stand outside this church on a weekend and hand out flyers for their prostitution services. So prostitution has already been decriminalised in New South Wales for a long time. So what this law is about is really removing any final taboo on sex work as something that's legitimate and just like any other job. And I think the insertion that you can stand outside or inside a church and solicit for sex is particularly insidious. And then finally, just onto surrogacy, the other changes that are proposed in this bill is to basically open the door for commercial surrogacy arrangements and remove any of the safeguards for women when it comes to surrogacy. Like at the moment, there are things like surrogacy arrangements in New South Wales can only be altruistic. The mother has to be at least the surrogate mother has to be at least 25 years of age, and other things like that. And the law currently says that if you breach any of these particular safeguards, then it doesn't matter. The end result for you won't be custody of the intended child, because if you've breached one of the safeguards, we see that as so severe that you shouldn't end up with custody of the child. Whereas the Greenwich Bill basically says, even if you do breach the age limit for the mother, even if you do breach some of these other safeguards that we've put around for her, if the court considers that it's in the best interest of the child for them to be with you, then we will allow that. And the problem with that is that all that encourages is the exploitation of increasingly vulnerable women. So, it'd be a lot easier to make a case that a child should stay with a committed homosexual couple with a dual income and everything like that than with the 17-year-old surrogate mother who's just given birth to the baby. So all it does really is increase the risk to vulnerable women in the name of equality. So the issue with this bill in particular, I think, apart from all of the little insidious aspects, is that it's so complex. In however many pages, it seeks to amend so many different areas of the law. I was going to say I love our politicians. I respect our politicians, but I don't believe that they can actually be over the content of a bill like that, a bill like this and all of their effects. And actually, some of them have been quite candid and said often what happens is you just look at somebody who you think knows what they're doing and vote in the same way as they do. So the real danger that this bill presents is that it's so complex that I don't think actually many of our politicians are going to be following it. So if I'm giving an action item for this one, I would say what we really want is for the government to reject the bill in its entirety, and that's what we should be asking for them to do. Because once you let them start voting clause by clause, I think we're going to get some sneaky things in. So that's where we are. And while it sounds a little bit doom and gloom, I'll go back to what John said at the beginning of this presentation, which is I think that the ecumenical dimension in particular has put us in a much better position now than we would have been if we were trying to fight this 5 years ago. I don't think that, the board can't get much blacker, but I don't think it can get as black as easily because of how much good work, even days like this are a testament to that. So we're in it for the fight. I'm so grateful there are so many of you here. And yeah, it's the next 6 months. Let's see what happens. Thank you very much.
Thank you, Monica. Yeah, we've got lots of great questions coming in, lots to cover. And so you need to cover all the problems that we have in New South Wales in 30-second answers.
Yep.
Euthanasia. But I'm going to add this to euthanasia and abortion at the same time. Are there any protections for nurses who might want to conscientiously object to assisting in such procedures?
I'd have to double check. I think it's any medical practitioner, and I think I think there are protections for nurses, but I can check that and you can ask me in the break. Yeah, I do think nurses have the ability to object, but again, if junior doctors might have a theoretical protection, but practically it doesn't work, how much more so for nurses who are who are under the direction of their superiors. So I think there is a conscientious objection right, I'll double check, but sorry, for nurses when it comes to euthanasia, they're not actually supposed to be, like all of the official roles are for doctors. So the legislation provides, like I said, the carve out for you don't have to prescribe, you don't have to administer, you don't have to be present for administration and all of those things, but the work of nurses is so much broader than that. And so the ability for them to conscientiously object to things like getting paperwork and whatever, however else nurses assist in the process, I think they could be be in some trouble.
Yeah.
Yeah.
Yes, there's a massive power differential.
Yes.
And also they just get assigned to a room, get assigned to a warden. Yeah, there you go, you're doing something. Woman's bleeding.
Exactly right, yeah.
Yes. Kamal's asked this question of 3 different speakers in a row. So, a very good, appropriate for you though, the anti-conversion legislation sounds like it sanctifies sexuality in a quasi-religious, quasi-theocratic, he's come up with sexocratic way.
I like that.
Please comment.
Well, absolutely. And one of the things that I say about this is that what it does is it prioritises somebody's sexual identity over their religious identity. So if I went to a priest and said, you know what, I'm same-sex attracted, but I want to live, my Catholic faith is more important to me than my sexual identity, and so what I want to do is I want help living out my Catholic faith, he's not allowed to help me do that. If I want help living out my sexual identity, I can go to anyone I like, but my religious identity I can't. So what the government is doing is saying, we will tell you that the most important part of your identity has to do with sex, not with faith. That's exactly what this legislation does, absolutely. You're 100% right.
And I was in a government consultation where you made that exact point quite firmly to a slightly disturbed bureaucrat who was going, I don't understand what you're doing. Do conversion to practice bill, the practices bill, or at least the proposal we've seen, impact conversations at home? Absolutely.
There is nothing that isn't covered by this. So yes, you could saying to your 15-year-old child, they're not under my roof rule, right? If you're going to live in this house, you're going to live by my rules, and one of them is you're not bringing your boyfriend or girlfriend over to spend the night. Even something like that could technically be seen as a conversion practice.
Okay. Did Chris Minns drop in conversion therapy before the election to win back Greenwich and the Labor left, who he lost because of gambling reform? Whether or not you've got opinion on that exact deal, the corollary is, how do we navigate when issues are traded off?
Yeah, look, I think that everyone was worried about being in a minority government. And so what you do is you make deals with the crossbench. And that's why we have abortion in New South Wales, because Gladys made a deal with Greenwich. How do we navigate those? Don't vote for independents in the lower house. And like that, but that's really it. Like if we're looking towards a federal election where there is concern again that the next federal election might see the government in minority government, whichever government it is, you're encouraging these deals. And so it's a bit of the prisoner's dilemma. But as much as we want to vote for independence in the lower house, I think we need to be careful about doing that and encouraging others to do that, because all it encourages is deals to be made.
Excellent. I think we've got time for one more. How do these potential legislations affect the age of minors and underage sexual practices?
Yeah, that's an interesting question. The two don't seem to connect, because the age of consent is still 16. I think, yeah, so the age of consent is still 16 in New South Wales. It's very strange. To be honest, there seems to be cognitive dissonance when it comes to the age of consent, and also other things. I mean, we don't let children consent to so many different things. They can't vote, they can't drive, they can't smoke, they can't do any of these things. But there doesn't seem to be any type of connection between the age of consent and what they're proposing in these laws. I suppose maybe they want to reduce Christian sexual ethics to you must comply with the law, you must comply with the law, and leave it at that. Yeah.
Excellent. We'll have more chance to ask Monica during the plenary and during lunch, but at the moment, please thank Monica.
Thank you very much.